Thank you. And, this is a great opportunity. As I was being introduced to my panelists several weeks ago, I found out that besides being renowned in their respective fields in data protection, data privacy, they represent the companies that I typically sue, just in the U.S. So it was great to hear the great legal minds defending those companies here in the EU, in the UK. And I'm going to have each of them announce them, introduce themselves, and say something about them that you might like the audience to hear. Please go ahead.
Thank you, John. My name is Geert Potjewijd, a partner with the Brauw in Amsterdam. As John was saying, a defense lawyer and representing tech companies in a number of the pending mass claims in the Netherlands under the Dutch framework for collective actions and the GDPR. David?
Thank you. So I'm David Barker. I'm a partner at Pinsent Masons in London. I lead our data and technology disputes practice. Probably of most note, I acted for Google in relation to their win in the Supreme Court in the claim brought by Richard Lloyd. Sinead.
Hi everyone, I am Sinead McLaughlin. I'm a partner at Covington in the disputes practice. I also do class actions generally, but with a focus on data. And I apologise that I can't be here in person. I am, in fact, going into court for one such matter, so have to join you all remotely.
Well, good. Well, let me start out by asking a question, then I'll have each of the panelists handle and maybe even provide some from the U.S. perspective. What approaches are being taken in different jurisdictions to the recoverability by individuals of damages for breaches of data protection privacy laws, especially those affecting groups of individuals? Maybe David?
Yep, I can kick off on that one, John. So the approach in English law to this question is essentially directed by compensatory principles. So I suppose in crude terms, yes, damages are recoverable in relation to breaches of data protection legislation, but you've got to show what happened to you individually. It breaks down really in the same way as it does under GDPR. So you can get damages for what's known as material damage if you can show that you have suffered some sort of tangible financial loss. So a good example of that would be if there's been some sort of cyber hacking, and as a consequence you have an account which has been compromised, some money has been taken from that account. There'll be a sort of very straightforward, tangible financial loss to point to in that situation. Then it's also possible to recover non-material damage, by which in English law we're talking about distress in that context. The range at the moment sort of seems to start around £250 sterling. There's a recent case about a politician who brought a successful claim, but it was pretty obvious the judge wasn't that sympathetic and awarded £250. We've got cases where the amount awarded goes up very significantly into the sort of tens of thousands for more extreme scenarios. To qualify for an award of damages for distress, the personal circumstances of the claimant need to exceed what you might call a de minimis or triviality threshold. And one of the points in the Lloyd case, which we'll come on to talk about a bit later, is that in English law, damages are not available for mere breach of data protection legislation. You have to show that there is evidence of something tangible and serious having happened to you that overcomes that de minimis threshold. And as we'll come on to, that's got some quite significant procedural implications, which I think is probably a topic we'll come on to in a little while.
Okay. Good.
Yeah, thank you. Talking maybe about the EU then, and the Article 82 of the GDPR that provides indeed, similar as the explanation under English law, for material compensation for material damages and also non-material damages. I think maybe one step back is to reflect on the fact that Article 82 GDPR is quite remarkable in a sense that it is one of the very few provisions in European law where the concept of damages has been identified and defined in a regulation. And I think that also explains why there are now so many cases that has been referred to the European Court of Justice for guidance, I would say, on how to actually explain and interpret this specific aspect of damages under the GDPR. If David, are you going to talk about the Lloyd the Google case?
I will, yeah.
Yeah, so I won't, let's say, discuss now the Dutch aspects of these claims, but I think it is important to note that the concept of damages under the GDPR is still, I would say, something that will need and require guidance from the European Court of Justice. And in that context, I think it is important to note that the Advocate General to the European Court rendered an opinion on the 6th of October 2022 and actually identified a number, I would say, of requirements. The first one is that the data subject has no right to compensation if he or she did not suffer damage. So that's, I think, the first, let's say, point. That brings him to the second point, where he rejects the idea that a mere infringement of the GDPR is tantamount to loss of control. And the next point is that loss of control does not equal damage. And that's an important aspect, I think, in the context of collective action. I will come back to that in a second. A third point in the opinion of the Advocate General is that the GDPR does not allow for punitive damages. The concept of Article 82 is very much to be seen in a context of compensation, as opposed to the regulatory enforcement that focuses on fines and criminal penalties. And the last aspect, and that goes to the heart, I would say, of the concept of the non-material damages. According to the Advocate General, mere inconvenience, being annoyed, being upset is not sufficient, actually, to qualify for damages. It must be something else, something more. And the Advocate General believes that that is best left to the interpretation by the member states.
I failed to mention at the beginning that we're dealing under the Chatham House rules, meaning no statement can be associated implicitly or explicitly to any one of us. So Paul, please don't let these come up. Paul Carlsgott, good friend of mine on the other side of the V and a lot of litigation in the U.S. The U.S. damages are going through development. Paul will tell you that that's a constant struggle. I think we've made some inroads. And I'll first talk about data breaches, where people's information is taken. It's taken not because the hacker is interested in looking for potential dates, but is intended to misuse that to steal people's identity to engage in fraud. We have in the U.S. a product of identity theft protection. It costs money to subscribe to that product. I've come up with a damage model that we first used in Capital One, where based upon the dates of birth of each of the 98 million people in the class, we ran through an actuary the life of each individual class member. We took that product, we priced it for the life of the class, brought it down to a present day value, and that was one of our damage models in the Capital One case. The court didn't rule on that because we settled that case before the court could rule on the motion for class certification. One of the other damage models at bottom is the concept that we borrow from the common law at the UK, where a lot of the US law is based, and it's the concept of nominal damages, which really is a Roman concept that for every wrong there is a remedy. And to the extent that you cannot prove how you were damaged in terms of dollars and cents, that you should be able to get nominal damages. And we have courts or juries, that have awarded nominal damages from anywhere of $1 to thousands of dollars. In the state of Virginia, which doesn't have a state class action device, courts have found it to be $100. So when you apply that across 1 million, 98 million, 200 million, you could add up to a lot of money. I had a lawyer argue against me in Capital One that, Mr. Yanchunis is seeking X amount of dollars. That's more than the value of Capital One, to which my response was, that's not my fault. It's not any one of my clients' faults that you lost their information to a hacker hosted on the Amazon cloud. In the data misuse context, we're refining concepts in some litigation that I'm actively pursuing in the US, based not upon the value of what the plaintiff lost, but what the defendant gained. It's the concepts that we look or use in unjust enrichment, for example, restitution, in the intellectual property model where you have infringement of a patent, copyright, or trademark. It's not what the plaintiff lost, it's what the defendant gained through that infringing conduct. So in data misuse, where a company has harvested information and is misusing it, well, they monetized it. So why isn't the measure of damages what the defendant gained, which is what I would argue in Lloyd the Google, where I give him the chance that to the extent that information was taken by Google and used, and I will tell you more likely than not, it was monetized in some way, and you can find that out through an economist. That would be the measure of damages. The damages then distributed equally among all class members. That would be the way in which I would approach that, David. So let me go on to the next one, and I could talk about this for the rest of the day, because it is a really great concept or topic. So what mechanisms are presently available or used in your respective jurisdictions for bringing data protection and privacy class actions?
Why don't I kick off on that one, John, and just kind of set the scene, which is, of course, in Europe, the GDPR, and that gives rights of action for data protection, as I'm sure comes as no surprise to this audience. But there are three key mechanisms that are worth mentioning. The first, obviously, is that data subjects themselves have the right to lodge a complaint with the relevant DPA or to bring a civil action. Second, you have the Article 81, which is effectively an opt-in system for representative actions, because data subjects can mandate not-for-profit bodies, organisations or associations to lodge a complaint on their behalf against regulators, controllers or processors, and also can mandate to receive compensation, can mandate those organisations to receive compensation on their behalf. And then we've got Article 82, which gives member states the option of going further than the Article 81 opt-in framework, and allows, again, your not-for-profits, organisations or association trifecta to lodge complaints or pursue claims without a mandate from the data subject. And so the threshold for bringing a claim there is that the relevant body must consider that data subjects' rights under the GDPR have been infringed as a result of the processing. So it's probably worth touching on the CJEU's decision on standing under Article 82 as well, in the Federal Union reference from Germany. And there the CJEU said that it was enough if the organisation was purporting to represent identifiable natural persons. So they don't need a specific mandate from data subjects. That's not a requirement, sorry. And then another point coming out of that decision, which is worth touching on, is that even though German law had not specifically implemented anything for Article 82 of the GDPR, it was enough that the national law, which had implemented the Injunctions Directive, already allowed consumer associations to take actions in respect of personal data protection. So Article 82 is broad enough if member states wish to establish opt-out based representative actions. But by and large, so far what we've seen is that the mechanisms available for bringing collective actions in the EU tend to be opt-in or effectively opt-in, because the damages stage is opt-in. Now, of course, we have a big deadline coming up at the end of the year for member states to implement the Representative Actions Directive. But again, it's not really looking at this stage like there's going to be a major move towards opt-out mechanisms. Of course, the notable exception being the Netherlands, but I think Geert's much better placed to speak about that than I am.
So Geert, why don't you pick that up in the
Yeah,
Netherlands?
yeah, thank you. So indeed, taking a look, let's say, at Article 80 GDPR, which provides for representative actions, I think the beauty of the Netherlands, if you wish, today, is that the opt-out collective framework for collective action has been in place for many years already. And so leaving aside the development of the GDPR, in the Netherlands, we already had this this framework for collective actions in place for quite some time. And it's on that basis that the Netherlands has become I would say, a hotspot for this type of data claims, because claim vehicles have identified this combination of being able to claim damages in the context of an opt-out representative action, which is, I think, unique on the continent within the EU. The big debate that is going on as we speak today is whether this Dutch framework for representative actions actually falls within the scope, the requirements, and I would say the limits of Article 80.2 GDPR. And taking a look, let's say, at that section, so Article 82 GDPR, if you take a look a close look at that provision, you will see that allows for a representative action without a mandate for a number of actions, but that provision does not refer to a claim for damages. And if you take a look at recital 142 of the GDPR, it says that this claim vehicle may not be allowed to claim compensation on data subjects' behalf, independently of the data subject's mandate. And so the huge debate in the Dutch context, and all these claims that are pending nowadays in the Netherlands are still in the admissibility phase. So we haven't yet got any guidance from any court on this question. But the real, let's say, and heavily debated question again is whether the Dutch framework for collective actions actually falls within the scope of Article 80.2 of the GDPR.
So David, under the English regime, perhaps discuss that along with the difficulties that exist post Lloyd versus Google.
Sure. Okay. So in the English regime, it's really a clear distinction between opt-in and opt-out situations. So in relation to opt-in claims, we have a procedure for making what's known as a group litigation order, whereby the court will manage numerous separate, quite distinct claims which have common issues, common factors in them. And the court will, under the terms of that order, manage those separate claims in a sensible and efficient way. So typically the court is going to be designating certain of the claims as lead claims or test cases. It's going to be designating certain law firms as being the firms that will have conduct of these claims, so you don't get a sort of unmanageable number of firms involved. And it's going to make stipulations in relation to things like costs and how cost liability might be shared as between the entire class. So for example, if you have a test case going forward, ensuring that all of the potential adverse cost burden is not falling upon the claimant in that case, when of course the benefit of that test case should really be seen as something which is shared amongst the entire claimant group. So that group litigation order procedure, I think, was used in the British Airways litigation following on from the cyber attack on BA. And I don't have the exact numbers, but I think it was in the tens of thousands, probably around 40,000 separate claims were pursued. So you can see that on a sort of opt-in basis, there's a sort of clear procedure there, and it's alive and well. And we're also seeing some firms try to do more innovative things too, such as bundling quite large numbers of individual claimants onto one claim form. So there we're talking about all those claimants being within one set of proceedings as opposed to being distributed between numerous proceedings but managed under a GLO. In relation to opt-out, the position is quite different. So, and here we need to look at the claim brought by Richard Lloyd against Google. So this was a novel attempt to use the representative action procedure which is quite a sort of legal backwater until recently. And really before the Lloyd claim, I think if you'd asked most English litigators, they would have looked at you blankly as to what this procedure was. Claim in relation to advertising cookies being set on Apple iPhones with a claimed class size of around 5 million individuals and a claim value of around £3 billion. One of the key reasons why Lloyd failed ultimately in the Supreme Court, and the Supreme Court decision was unanimous, all 5 judges sided with Google, comes back to the points I was making earlier in relation to compensatory principles. So in Lloyd, the Supreme Court said that it would need to be satisfied as to what damage had been suffered by each individual member of the claimant class. And within that, it would need to be satisfied that individual members of the claimant class, in some or many instances, had not actually just suffered a level of damage which fell well below that de minimis threshold that I talked about earlier. And clearly, if you're talking about a class size in the millions, then it's not practicable to have that sort of forensic investigation as to what has happened to each class member. And so, as well as obviously Lloyd's claim failing at that stage, there were about half a dozen other claims which had been commenced and stayed pending the outcome of the Supreme Court appeal in Lloyd. They've all since fizzled out. And then there were probably a bunch of other claims which have been issued but not served with sort of various claimant firms and representatives wanting to get control of the board in relation to those if they could proceed. So again, they weren't served. So really a clear distinction between opt-in and opt-out. And on the opt-out front, at the moment, Lloyd represents a significant barrier subject to perhaps an angle around competition, which I think we're going to come on to, John.
Okay. Yes, please.
Yeah, maybe just one comment in addition to David's comment of the UK. Just a few words on these actions pending in the Netherlands, where the claim vehicles basically assert a claim on the basis of the loss of control. So very much in the same way as it was done in the UK. And it's done in a way that I think Nicole mentioned €100, let's say, per user, but actually it's, I think it usually starts with €500, and then for the entire class, which could be all users of a social app network, a network app, or for even all internet users in the Netherlands. So if you take, let's say, 10 million people in the Netherlands, €500, again, that's a claim of 5 billion. And so that's the way this concept of damages has been used. And to the first point, in the context of that opinion of the Advocate General, it will be very interesting to see whether these claims actually will be declared admissible in a Dutch context, in the same way as was decided in the UK.
Yes, the Advocate General's opinion is very much on all fours with Lloyd. And what you were saying earlier, Geert, about damages for mere loss of control not being available, that's exactly the approach which the Supreme Court took in Lloyd as well.
Let me go on to the next topic and ask this question. And first start with Geert. How might the intersection between competition and data protection contribute to the development of claims in this area?
Thanks, John. I think it's clear from what we see, let's say, in all European countries, there is a clear convergence of claims based on GDPR infringements, competition, and also consumer protection. And we see various claims coming up, in many times, let's say, combined. And we also, let's see the regulators step in. And I think the question for today is this convergence of various claims, will that, let's say, provide for new avenues for claim vehicles actually to bring collective actions in the context of GDPR infringements? It's not something that is happening as we speak in the Netherlands, and that is because our framework for collective actions is basically for any type of claim. So we don't basically need that new avenue in a Dutch context. But it's quite clear that there is this convergence, and There is now in the regulatory framework also an opinion of the Advocate General with the European Court saying indeed that a competition regulator, in this case a German, is actually entitled to take into consideration a GDPR infringement to assess whether, in this case, Facebook had an abuse of its dominant position. So it is clear that the competition authority has that possibility. At the same time, it is also clear that the competition authority is not the right authority to establish an infringement of the GDPR. So I think it's a bit of a balancing act when it comes to the regulators in terms of their powers to investigate, and at the same time, the opportunity for them to actually establish an infringement. But that's very much in the context of the regulatory framework, and I think...
we've actually got something similar in the CAT. I mean, the Competition Appeal Tribunal in the UK, but I think they're probably driven more by the class action mechanism, which is available in the CAT in the UK, which isn't available elsewhere. And David mentioned the innovative attempts to bring collective actions in the UK, and I think we are really starting to see that in the Competition Appeal Tribunal post Lloyd and Google. And a good example of this actually is also in a claim that's been filed against Meta. By the proposed class rep, Dr. Liza Gormson. And really at its heart, when you look at that case, it's a data privacy claim, but the way the allegations have been put to bring it within in the jurisdiction of the Competition Appeal Tribunal and the opt-out mechanism that's available there is that Meta's or Facebook's terms and conditions, among other things, are an abuse of dominance. So it's been filed, the certification hearing has been set down for January, and I think that's one that will probably be quite closely watched to see what the CAT does with this claim.
David, how about you?
Yes, so it's interesting to contrast the Gormson case and the way that that's put with the Lloyd case. And the key thing there is that as well as being a sort of bespoke procedure for competition claims generally, the CAT procedure has a different approach potentially in relation to damages. And that involves a potential move away from the compensatory principle, which acts as something of a straitjacket in relation to claims under the representative action procedure. So the competition procedure allows for the possibility in appropriate cases of an aggregate award of damages, what you might call more of a sort of top-down rather than bottom-up damages award. And in, obviously we talked quite a bit in sort of different contexts about Merricks today, but just worth recapping in relation to the key finding that the Supreme Court made in that case. The Supreme Court was less concerned about the possibility of individual class members being overcompensated based on their own specific circumstances. It didn't see that as such of a problem, as long as there wasn't a possibility that the defendant was ultimately going to be punished, was going to pay more in aggregate than the amount by which it had benefited. And I think that's the sort of significant shift in the Supreme Court in that case, and that is why the court was prepared to make a collective proceedings order and allow the case to proceed at least to the next stage, because it was satisfied that there may be a basis upon which damages could be calculated in aggregate which wouldn't do an injustice to the defendant.
Sinead, do you think the UK is headed for a generic opt-out procedure as a bespoke competition claims procedure?
Well, it was always, that procedure in the CAT was always intended to be a pilot. So we've had it now since it's been in place since 2015, but it's only really got going in the last few, well, since Merricks, so in the last few years, and it's got a long way to go. But I think it's, you know, I think the expectation certainly in the market is that if it's going to be expanded, data was probably going to be the obvious next area for it to be rolled out. But actually, as it happened last year, the government published a consultation on the Data Protection Act and looked specifically at this question of whether they needed an opt-out, whether we needed an opt-out collective redress mechanism for these representative actions, and actually decided no, that we didn't need it. It's it's really for the ICO to carry out the consumer protection function for now. I think, of course, that was at a time when we only had the Court of Appeals decision in Lloyd and Google on representative actions, and where it was looking like the 19.6 mechanism, which is the representative action mechanism that was in play there, might be used as more of an opt-out mechanism than what the Supreme Court's decision suggests. And the government was specifically relying on that, on the developments in that case in reaching its decision. So it could, maybe they will come back to it. The UK government's got a lot of issues that it's dealing with at the moment, so I'm not sure how much of a priority this will be. But you know, David, you might have views on where you think that's going to go as well.
Yeah. I think more generally, it's worth just maybe doing a sort of quick rewind in terms of recent history on the possibility of introducing a sort of more generic opt-out mechanism in the UK, which obviously then would be a route that data claims might be able to follow. So back in 2008, the Civil Justice Council actually recommended the introduction of a generic opt-in procedure. In 2009, the government at the time responded to that, said that it was unconvinced that we needed a generic procedure, and said instead that things should be done on a sector-by-sector basis. I've always been confused by that term, sector by sector, because I think really perhaps it's more about cause of action by cause of action. Obviously, competition is the only one which we have seen introduced so far. There was at one stage the possibility of introducing a generic procedure in relation to financial services claims, but I think that got probably sidelined in part because we had a sort of bespoke compensation scheme introduced in relation to certain financial products mis-selling. So not a opt-out procedure, an opt-in procedure, but one that was pushed quite hard. I'm personally doubtful that we're going to see the introduction of a kind of generic procedure in the UK in the sort of shortish term. So I wouldn't say in the next 3 years that this is likely to happen. I think Sinead's absolutely right. We've got a government under our third or fourth Prime Minister, I'm losing count, but they have a huge amount on the agenda, lots of challenges, lots of things to stabilise, lots of priorities, and I just don't really see this as being something which is really sort of top of mind. And I think, John, actually, one of the issues there is that there's still quite a sort of perception that there's lots of sort of negatives around class actions, and there's a perception that maybe the way that things have happened in the US, there are a lot of undesirable aspects to that. You know, things were mentioned earlier around stats about how much of the sort of compensation ultimately goes to class members, those kind of things. Some of that may be unfair. I think that's probably a very sort of kind of knee-jerk view, which probably doesn't take into account the detail of different procedures in different states. But you were asked in the previous panel about what the EU and the UK can learn from the sort of US experience in relation to class claims generally. I wonder if there are sort of things that could be learned specifically in a data context.
Certainly. So, you know, when you consider the concept of privacy in the US, is really a 19th century concept. And we're taking that 19th century concept of claims that were created by first academics and then adopted by courts, and we're applying it to 21st century technology. And a lot of our judges were educated in the 20th century and haven't really come to grasp with the way data is used today. I mentioned earlier that to some that the biggest companies on the face of the earth don't make anything anymore. They don't make cars. They don't make steel to put in buildings. The biggest companies on the face of the earth today, the ones that are the biggest that make the most money, are the ones that deal with data, data collection, and the monetization of data. And I include in that Amazon. Amazon has half the world cloud computing market, and the information they have in there as 3 buckets under their control is massive. So our struggle in the US, which has resulted in some of the bad, but you know, it's like, who would go into a restaurant if they saw how food was cooked in the kitchen? Not many. So I think we're going through, and the good thing about the litigation model in the US is you pay a filing fee and you're in court, and hopefully you're experienced enough to do right. And I think through the better lawyering that Paul and I are engaged in, even though we're on opposite sides of the V, is to begin to harden some of these concepts that really need to come forward into the 21st century and recognize how data is used. There's a bank robber who was very famous in the 30s and 40s, and when he was apprehended in the 50s, someone asked him, why'd you steal money from banks? And his answer was, that's where the money is. So for those who hack and steal data from companies, that's where the money is. But as I've said earlier, and we said today, you're starting to see, you know, the way, I prefer the way the EU and the UK, and that's the loss of data, loss of control, instead of perhaps data misuse. Because in the US, we're starting to go through the concept of each one of us should be able to control our data. We have states, like the state of California, that is on the cutting edge of recognizing an individual's interest in data, and have come up with concepts and claims to monetize that if it's abused or lost in a data breach. The state court governments are somewhat slow to adopt that, but we have now Virginia, New York, and Illinois. The federal government probably, particularly since now we have a divided Congress, isn't going to be doing much. I think I read today the House is going to start investigating and impeaching Joe Biden, for God's sake, rather than doing the public good. But I'm not sure there's going to be any nationalization of a claim. So what you can learn from the US model is that we're going to continue to refine the types of claims outside of statutory-based claims that exist in California, for instance, and those other few states, and come up with ways of measuring how a consumer should be compensated when they're affected, whether it be a loss of control or a data breach. And I would say, since I've been, you know, in this practice, in that focus since 1999, it's really in the last couple of years where we've begun to really recognize how to monetize it. But again, they're concepts that have not yet, you know, reached to a point where a court would say, Mr. Yanchunis, you're right. That's the way in which we're going to measure. And then we've got this fiction of Article 3 standing, which doesn't exist in the Constitution, despite what you see from SCOTUS, but in 1970, somebody came up with this injury in fact concept. So in the data protection, data privacy, we're dealing with this injury in fact, and some courts have said, well, that means some tangible injury. But again, it's not grounded in the Constitution. And one of the things that, for instance, when we were arguing the Home Depot data breach. Home Depot is a big retailer. They sell hammers and lawnmowers and such. Lost 65 million people's payment card information. And we were arguing that the time spent by any consumer was a compensable injury. And that recently was recognized in the 11th Circuit, which is the appellate court that controls the federal system in the South, most of the South. And they recognized, not in a data breach case or a data privacy case, but that the time spent to address an injury was a compensable claim. Difficult to apply, Paul, this is not attributed to me in any filing, on a class basis, but it is at least a tangible injury that will get us past a motion to dismiss.
Interesting. Lots to go at.
Yes.
We'll be back here a year from now and 5 years from now talking about further developments and where we'd like to be and where we're not. So I think we've run out of time, but we'll have, if there's any questions from the floor, we've answered them all. Nobody has a question. Okay. Well, we're all around and accessible after this session. Thank you so much.